Please subscribe, like and share this content. It means a lot to us. Thank you in advance.
To U.S. Code Chapter 9D, Office of Senate Legal Counsel. To U.S. Code Paragraph 288G, Advisory and Other Functions. A. Cooperation with persons, committees, subcommittees, and offices the counsel shall advise, consult, and cooperate with. 1. The United States Attorney for the District of Columbia with respect to any criminal proceeding for contempt of Congress certified by the President pro tempore of the Senate pursuant to Section 194 of this title. 2. The Committee of the Senate with the responsibility to identify any court proceeding or action which is of vital interest to the Senate. 3. The Comptroller General, the Government Accountability Office, the Office of Legislative Counsel of the Senate, and the Congressional Research Service, except that none of the responsibilities and authority assigned by this chapter to the counsel shall be construed to affect or infringe upon any functions, powers, or duties of the aforementioned. 4. Any member, officer, or employee of the Senate not represented under Section 288C of this title with regard to obtaining private legal counsel for such member, officer, or employee. 5. The President pro tempore of the Senate, the Secretary of 1. Senate, the Sergeant at Arms of the Senate, and the Parliamentarian of the Senate, regarding any subpoena, order, or request for withdrawal of papers presented to the Senate which raises a question of the privileges of the Senate. And 6. Any committee or subcommittee of the Senate in promulgating and revising their rules and procedures for the use of congressional investigative powers and with respect to questions which may arise in the course of any investigation. B. Legal research files. The counsel shall compile and maintain legal research files of materials from court proceedings which have involved Congress, a House of Congress, an office or agency of Congress, or any committee, subcommittee, member, officer, or employee of Congress. Public court papers and other research memoranda which do not contain information of a confidential or privileged nature shall be made available to the public consistent with any applicable procedures set forth in such rules of the Senate as may apply in the interests of the Senate. C. Miscellaneous duties. The counsel shall perform such other duties consistent with the purposes and limitations of this chapter as the Senate may direct. 2 U.S. Code Paragraph 288 Hours. Defense of certain constitutional powers. In performing any function under this chapter, the counsel shall defend vigorously when placed in issue. 1. The constitutional privilege from arrest or from being questioned in any other place for any speech or debate under Section 6 of Article I of the Constitution of the United States. 2. The constitutional power of the Senate to be judge of the elections, returns, and qualifications of its own members and to punish or expel a member under Section 5 of Article I of the Constitution of the United States. 3. The constitutional power of the Senate to accept from publication such parts of its journal as in its judgment may require secrecy. 4. The constitutional power of the Senate to determine the rules of its proceedings. 5. The constitutional power of Congress to make all laws as shall be necessary and proper for carrying into execution the constitutional powers of Congress and all other powers vested by the Constitution in the government of the United States, or in any department or office thereof. 6. All other constitutional powers and responsibilities of the Senate or of Congress. And 7. The constitutionality of acts and joint resolutions of the Congress. 2 U.S. Code Paragraph 288I. Representation, conflict or inconsistency. A. Notification. In the carrying out of the provisions of this chapter, the counsel shall notify the Joint Leadership Group, and any party represented or person affected, of the existence and nature of any conflict or inconsistency between the representation of such party or person in the carrying out of any other provision of this chapter or compliance with professional standards and responsibilities. B. Solution. Publication in Congressional Record. Review. Upon receipt of such notification, the members of the Joint Leadership Group shall recommend the action to be taken to avoid or resolve the conflict or inconsistency. If such recommendation is made by a 2/3 vote, the counsel shall take such steps as may be necessary to resolve the conflict or inconsistency as recommended. If not, the members of the Joint Leadership Group shall cause the notification of conflict or inconsistency and recommendation with respect to resolution thereof to be published in the Congressional Record of the Senate. If the Senate does not direct the counsel within 15 days from the date of publication in the record to resolve the conflict in another manner, the counsel shall take such action as may be necessary to resolve the conflict or inconsistency as recommended. Any instruction or determination made pursuant to this subsection shall not be reviewable in any court of law. C. Computation of period following publication for purposes of the computation of the 15-day period in subsection B. 1. Continuity of session is broken only by an adjournment of Congress signed I, and 2. The days on which the Senate is not in session because of an adjournment of more than 3 days to a date certain are excluded. D. Reimbursements. The Senate may by resolution authorize the reimbursement of any member, officer, or employee of the Senate who is not represented by the counsel for fees and costs, including attorney's fees, reasonably incurred in obtaining representation. Such reimbursement shall be from funds appropriated to the Contingent Fund of the Senate. 2 U.S. Code Paragraph 288G. Consideration of resolutions to direct counsel. A procedure, rules. 1. A resolution introduced pursuant to Section 288B of this title shall not be referred to a committee, except as otherwise required under Section 288A(c) of this title. Upon introduction, or upon being reported if required under Section 288A(c) of this title, whichever is later, it shall at any time thereafter be in order, even though a previous motion to the same effect has been disagreed to move to proceed to the consideration of such resolution. A motion to proceed to the consideration of a resolution shall be highly privileged and not debatable. An amendment to such motion shall not be in order, and it shall not be in order to move to reconsider the vote by which such motion is agreed to. 2. With respect to a resolution pursuant to Section 288B(a) of this title, the following rules apply. A. If the motion to proceed to the consideration of the resolution is agreed to, debate thereon shall be limited to not more than 10 hours, which shall be divided equally between, and controlled by, those favoring and those opposing the resolution. A motion further to limit debate shall not be debatable. No amendment to the resolution shall be in order. No motion to recommit the resolution shall be in order, and it shall not be in order to reconsider the vote by which the resolution is agreed to. B. Motions to postpone, made with respect to the consideration of the resolution, and motions to proceed to the consideration of other business, shall be decided without debate. C. All appeals from the decisions of the chair relating to the application of the rules of the Senate to the procedure relating to the resolution shall be decided without debate. B. Committee defined for purposes of this chapter, other than Section 288B of this title. The term committee includes standing, select, and special committees of the Senate established by law or resolution. C. Rules of the Senate. The provisions of this section are enacted, 1. As an exercise of the rule-making power of the Senate, and, as such, they shall be considered as part of the rules of the Senate, and such rules shall supersede any other rule of the Senate only to the extent that rule is inconsistent therewith, and 2. With full recognition of the constitutional right of the Senate to change such rules at any time, in the same manner, and to the same extent as in the case of any other rule of the Senate. 2 U.S. Code Paragraph 288K, Attorney General relieved of responsibility. A. Upon receipt of written notice that the counsel has undertaken, pursuant to Section 288C(a) of this title, to perform any representational service with respect to any designated party in any action or proceeding pending or to be instituted, the Attorney General shall, 1. Be relieved of any responsibility with respect to such representational service, 2. Have no authority to perform such service in such action or proceeding except at the request or with the approval of the Senate, and 3. Transfer all materials relevant to the representation authorized under Section 288C(a) of this title to the counsel, except that nothing in this subsection shall limit any right of the Attorney General under existing law to intervene or appear as amicus curiae in such action or proceeding. B. The Attorney General shall notify counsel as required by Section 530D of Title 28, 2 U.S. Code Paragraph 288 Leaders. Procedural provisions. A. Intervention or appearance. Permission to intervene as a party or to appear as amicus curiae under Section 288 of this title shall be of right and may be denied by a court only upon an express finding that such intervention or appearance is untimely and would significantly delay the pending action, or that standing to intervene has not been established under Section 2 of Article 3 of the Constitution of the United States. B. Compliance with admission requirements. The counsel, the deputy counsel, or any designated assistant counsel or counsel specially retained by the office shall be entitled, for the purpose of performing his functions under this chapter, to enter an appearance in any proceeding before any court of the United States or of a state or political subdivision thereof without compliance with any requirement for admission to practice before such court, except that the authorization conferred by this subsection shall not apply with respect to the admission of any such person to practice before the United States Supreme Court. C. Standing to sue. Jurisdiction. Nothing in this chapter shall be construed to confer standing on any party seeking to bring, or jurisdiction on any court with respect to, any civil or criminal action against Congress, either House of Congress, a member of Congress, a committee or subcommittee of a House of Congress, any office or agency of Congress, or any officer or employee of a House of Congress or any office or agency of Congress. 2 U.S. Code Paragraph 288 Minutes. Contingent Fund. The expenses of the office shall be paid from the contingent fund of the Senate in accordance with Section 6503 of this title, and upon vouchers approved by the council. 2 U.S. Code Paragraph 288N. Travel and related expenses. Funds expended by the Senate Legal Counsel for travel and related expenses shall be subject to the same regulations and limitations, insofar as they are applicable, as those which the Senate Committee on Rules and Administration prescribes for application to travel and related expenses for which payment is authorized to be made from the contingent fund of the Senate.